Hello, everyone. Good evening and welcome to Get Set Law. So, today we are going to discuss the Fortnightly Law Scope October Part 1. So, we'll be going to discuss certain important legal current affairs which has happened in the last 15 days. So, let's get started. Electoral bonds case. The Supreme Court will hear the batch of petition which have been challenged in respect to the electoral bond. Now, what is electoral bond and what is the issue? It is very important to understand that electoral bond is a very important instrument when it comes to the funding of a political party. So it has been seen that whenever any political party has to raise a donation, has to raise funding for their political purposes, it has to be done via the electoral bond. Now, the system has been made so that proper donations can be raised for the public party, and that is why it is very important that they need to be there accordingly. So, a Supreme Court is dealing with a batch of petition which have been filed in this regard. And now the concern is that is electoral bond valid in nature or not? So, by the virtue of 2017 amendment, so which has been made into section 29C, the Representation of People's Act 1951. Now, what will happen is that a donor may buy electoral bond at specified banks and branches using the electronic modes of payment. And after he's done with his KYC, that is know your customer requirement, he is eligible to pay any certain amount. So the denominations are also fixed, which is in the multiples of 1,000, 10,000, 1 lakh, 10 lakh, and so on. So this is the condition that is required for you to pay the certain amount to the political party. Now, the one of the important and I will say a disputed fact here is that political parties are not mandated that they will disclose the list of donors who have given the funding. So this is a prime issue over here where people have been questioning the point of how much open it is, how much transparent it is with respect to the functioning. Because when we talk about being in a democratic country where we use the word people quite often, that it is for the people, by the people, of the people. So why people are not aware that who is giving money? Who knows money is coming from outside? Who knows a criminal is funding? Who knows from where the money is coming? So this is one of the biggest concern that, because it is very obvious that the one who is giving money to the government, the person will be the benefited, right? So that is why it is a very important question here. And let us know in the comment section that what is your opinion in this regard. Do you actually think that this should be disclosed or it should be leave as it is now? Now, another thing is that name of donor will also be not there in the bond. So it's not that, you will give the name and then party will not disclose it, but the name of the donor itself will not be there. And the validity of the bond will be just for the 15 days from the date of issue. So this is done by the State Bank of India, and 1 to 15. So from the any first day of the month up till the 15th day, the bond will be valid whenever it is issued by the bank. So now the point is that they have also given the exemption. So if you give the donation to the political party, you'll be exempted from your income tax under section 13A of the Income Tax Act 1961. So this remained another concern, whether this has just become means to shift our focus from one side to another, right? So how can we manage to dodge this, where we can maintain transparency also, and the government can get the fund also? So this is one of the major concern with respect to with the petition has been filed, and the Supreme Court is going to discuss this. So let's see what is the dictum of the court in this regard. Suspension of Rajya Sabha Member of Parliament Raghav Chadha. So Aam Aadmi Party MP Raghav Chadha Now he has approached the Supreme Court challenging his suspension from the Rajya Sabha. And then in a very recent past, we have also seen that one of the very famous MP, Rahul Gandhi, has also been disqualified from the Lok Sabha. And we can see that Raghav Chadha has not been disqualified, but he has been suspended for a particular period of time. So it is very important to understand the procedure, that how this disqualification or how this suspension takes place, and the first of all, why it take place, why it so happen that a particular MP is suspended. So we can see that under Constitution of India, we have a provision under Article 102 which talks about the disqualification of the members. So there are certain terms and conditions, very general terms, like you should not maintain the office of profit, right? So if a person has office of profit, so he may be disqualified, he may be suspended from the member, from being member of the parliament. Now, there is another thing that you have to maintain the decorum in the parliamentary proceedings. So he has been suspended on 11th August, where he had been allegedly obstructed the parliamentary proceedings, and thereafter the matter initiated, and very soon he got suspended. So thereafter, it has been seen that Raghav Chadha had tried to approach the court seeking that the action taken against him is not appropriate and it needs to be rectified. So now, okay, yeah, I think certain someone has come. Okay, yeah, it must be audible now. Okay, so every parliamentarian has a parliamentary privileges. Parliamentary privileges have been given under Article 105 of the Indian Constitution, where every parliamentarian has got certain privileges with which allows them to be in the parliament very freely. And this gives them the power that they can present their opinions in a free manner. So that is why it is very important. But in the present case, the leader is opposing his suspension because it's an indefinite suspension and he is terming it as illegal and the arbitrary. Now, as I mentioned about the parliamentary privileges which have been given under Indian Constitution, these are the few very important privileges which every parliamentarian gets. And if they try to breach this privileges, if they try to move out of the boundary of the privileges, then they may get suspended. So freedom of speech in parliament. So we have our general right under Article 19, where every citizen gets the freedom of speech, but it comes with a certain restrictions. But in the case of parliamentarians, the case is not true, and they have been given certain liberty that they can, use their freedom of speech in a much broader way as a normal citizen will use under Article 19. So that's what make a difference between the general citizen and a parliamentarian. Second is freedom from arrest. So these members enjoy the freedom of arrest and in any civil case. So the benchmark is of 40 days, that is before and after the adjournment. So after the adjournment is basically whenever the house is in the process. So 40 days, so let's say the house is going to start at 1st December. So if it is going to start on the 1st December, 40 days before, and if it is going to adjourn on 30 December, so 30 December, say 40 days more. So this is the parameter, this is the length that from 40 days before and after the adjournment of the house, they get this privilege that they cannot be arrested. And right to prohibit the publication of proceedings. Now, if they publish any report which has been, been a part of the discussion or discussion itself of the house. So if they publish such things, they cannot be prohibited, right? So this is a right which they have inherited only in the cases where the matter is of the national importance, which is a very paramount issue. So in that cases, proceedings should be communicated to the public that such and such thing happened and we want to take an action against a parliamentarian. Right to exclude strangers. So now parliamentarian also has the right that some stranger who do not, they can exclude if they are not the member of the house. And because we want free and fair discussions, so sometimes some strangers are allowed in the house to witness the discussion in the parliament, and the parliamentarians can use this right to remove those particular strangers so that they can engage in a free and fair discussions. Draft Patent Amendment Rules 2023. Now we have come with a very important and significant change in the patent rules. Patent comes under the intellectual property right. We have seen that we have few categories under intellectual property right, like patent, copyright, trademark, geographical indicators, industrial design, and so on. So this is the list of the IPRs we have, and we have got certain changes in patent rules. Now, the most important change which we have brought forward is that we have granted the right to the controller. So we have a controller of the patent. So we have granted the right that he can decide the maintainability of the representation. So now there is a concept called pre-grant opposition. So whenever a patent has to be granted, there may be a pre-grant opposition which can be raised by the individuals or civil society for not granting patents to a particular organization or person, and they can submit their reasons and the rationales behind why the patent should not be granted. And now this right has been given to the controller that he can decide the maintainability of the representation, that how valid those representation are, where it has been opposed for granting the patent to particular organization or particular individual. So pre-grant opposition, we will understand it is an important public health safeguard, which is against a patent evergreening and unmerited monopolies. So one of the important issue with respect to the patent is that we are facing the evergreening patent issue. Evergreening matlab, only one company gets the right and gets the patent over a particular product, maybe like a generic medicines. So like the things like this should not be given an evergreening patent where only one company will have a right for life that they can only manufacture that product solely. So this is something called a patent evergreening and unmerited monopoly. So they will gain a monopoly over the specific object, and they will have the exclusive right. So this is why the pre-grant opposition is considered to be an important tool under the hands of individuals or the civil societies. Now, if we talk about the existing rules which are given under Article 12, Clause 2, patent applicants are required to inform the controller about application filed in other countries. So basically, if the company or if any organization which is registered in India, but if they are trying to sell their product outside and if they have filed the applications in other country with respect to the patent, they have to inform the controller about this, and this has to be done within the 6 months. So this was the existing rule. Now we have got the new rule which says that it has to be informed to the controller within the 2 months. So basically we have become stricter toward this rule that it has to be done very quickly so that the application can be processed. Because let's say if you apply in another country for the patents and after 6 months you are informing the controller, it will be too late for the Indian authorities to take any action if they want, right? So sometimes it becomes, the action cannot be undue by the authority. So that poses a different kinds of challenge in the industrial level. Then we have deep fakes. Deep fakes is a very new phenomenal thing which is coming up. And now you must be aware that we are living in the era of artificial intelligence. Now, with that artificial intelligence, like it is helping an individual to cross over multiple things, it is also becoming a tool of, tool of curbing someone's privacy, tool of defaming someone, tool of humiliating someone. And one such example is deep fakes. So deep fakes is a combination of deep learning and the fake. So now what happens is that oftentimes you will realize that someone, if they takes our picture, they takes our images, or if they find it from any browser, social media, they can use it for a pornographic purposes or any other similar purposes. So multiple women have been caught in this act, and their images have been stolen. And from, because certain time we find that the people's social media are open and their images are available in the browser, maybe through the LinkedIn portal, maybe through their Facebook, or by any appearance of them in any of the social media, because of which the image is also available in the browser. So because of this, their images have been leaked and have been taken by someone from their social media, and they had made it some bad videos out of it, and they demanded unwanted money. So this was the case which have been faced by the multiple women in this regard, and because of which they had been humiliated. Their fundamental right have been breached, their privacy have been breached. So we have got right to privacy under Article 21 of the Indian Constitution, which enshrines, which encompasses certain rights, specifically personal liberty. So now this is very important that we should tackle this issue in the present era. As of now, we are weak in the terms of legislative capacity, but we are competing in that sense that we can also come up with a strong legislation which is going to deal with all of these issues. So the point is that this kind of activities have to be controlled. The usage of AI has to be controlled so that we can, save the privacy aspect. So if we talk about laws which exist in India as of now for tackling the present challenges, we have Section 66E and Section 66D of the Information of the Technology Act 2000, in which we have been given severe punishment and fines. So Section 66E of the IT Act says that if anyone tries to do the privacy violation, where someone is trying to capture your image, try to publish it and transmit it in the social media or any mass media platforms, you will get a punishment of 3 years, and even fine will be imposed up to 2 lakh rupees. However, if you use Section 66D, and if someone is trying to, using the communication devices for a malicious purposes or any other computer resources, we can allow them the imprisonment for a period of 3 years and a fine of 1 lakh rupees. So this is one of the important element that with the help of this legislation, we can help our community to move forward. So this is the very important information. Share with your near and dear ones, share with your friends, share in your community that if this kind of thing happen, this is the law which you need to, take help. So you can take the screenshot of the screen and keep it with you, because these are the important aspects which any one of us can face in the present era, where all of us are in the ambits of social media, right? So this was all for today, and hope you liked it. Hope it was of some value to you. And I will see you very soon in the next series. We'll come up with the October part in the next video. Thank you for watching and see you soon.